Welcome, LA Progressive friends and family. Dick and I are once again joined with Bill Blum, who just always gives us some really insightful information about Supreme Court decisions and other legal matters. Bill is a former judge and death penalty defense attorney. He's the author of 3 legal thrillers published by Penguin Putnam. And he often contributes his writings to Truth Dig, LA Progressive, and other important political and social justice magazines. Thank you, Bill.
You're welcome. It's great to
How
be
you
here.
doing, Bill? So today we're going to talk about a recent article you put out called "How the Supreme Court's Shadow Docket Facilitates Trump's Power Grab." Right off the bat, can you tell us what a shadow docket is?
Okay, so the shadow docket is not a legal term, it's a colloquial term. It's given to emergency appeals that the Supreme Court of the United States decides on an expedited basis outside of the procedures that apply to its standard merits docket. So to understand what the shadow docket is, let's start with the merits docket. Each year, the Supreme Court decides about 60 cases now. The merits docket has dwindled in terms of its numbers over the past 10 years. Those cases are decided with full briefing, oral arguments, invitations to amicus curiae to participate, often with invitations to the Solicitor General, where the United States is not a party. And as far as the court having any kind of transparency, which is already very little, you have the maximum amount with what we call the merits docket. The rest of the court's workload is technically on what's called the orders list. So the orders list could consist of 7,000 or so cases a year in which parties ask the Supreme Court to accept their case for review. And usually the Supreme Court would just deny requests with a one-line sentence saying petition denied. The shadow docket is a term given to that subset from the orders list that refers to high-profile emergency requests that kind of jump the queue, jump the line that otherwise applies to the merits docket and ask the Supreme Court for immediate relief. And usually those cases ask for the court to lift a lower court injunction, a lower court order that blocks something or that requires something. And those cases, when the Supreme Court enters its ruling, the court doesn't provide for oral argument as a rule, provides for very summary, short decisions, and doesn't allow for full briefing. And yet it makes very consequential decisions. We had 2 today, June 6th, involving DOGE, this bogus Department of Government Efficiency. And those 2 rulings, number one, allowed DOGE access to Social Security records. A lower court had blocked that. Right. So the Supreme Court enters, lifts the order, stays that order, and says, we believe that the government would prevail on the merits, but this isn't a final decision. But everybody pretty much knows that that is the final word, that if it ever comes back to the Supreme Court, they'll issue a ruling consistent with their shadow docket ruling. The other one involved an effort by a private group to obtain information from DOGE about its operations, a Freedom of Information Act request. That was ordered by the lower court, so now that's stayed. And we're seeing a proliferation of these so-called shadow docket rulings, and that's a term now that everybody's using. It was first coined in 2015 by a law professor, and we're seeing more and more of them now. And it's a way for the court to issue rulings, sometimes in the dead of night. It's really interesting. And in the Trump era, those rulings tend to be in his favor, in favor of expanded presidential power. And that's why those rulings are said to increase the power of the presidency, as I wrote. But the original title in Truthdig was Beware the Shadow Docket. So people should know that there's this parallel set of emergency rulings that commentators call the Shadow Docket that parallels the usual caseload of the Supreme Court when we think of the Supreme Court holding its oral arguments and considering all the briefs, finally issues opinions. And those opinions tend to be quite long and well-reasoned, even if you think that the reasoning is wrong, they're highly detailed. So that's the gist of the article, and it's to call attention to this process for a lay audience, for people who might not know that this is what's going on behind the scenes. And it's just another indication of how this Supreme Court is very conservative. And if you're relying on the court, this court, not the lower courts, to really be a bulwark against Donald Trump, I think you're going to be somewhat, if not overwhelmingly disappointed. It's not that the court will never stand up to Donald Trump. It did issue an order in the Abrego Garcia case, which was a shadow docket ruling, that they should facilitate his return. And lo and behold, he's back today, but he's facing this indictment for trafficking. And then there was another shadow docket ruling more recently, which said regarding a subset of plaintiffs from northern Texas that you can't use the Alien Enemies Act of 1798 to deport them. But it said also this ruling doesn't preclude the government from using other means to deport those people. And there are other means, and the government is using those other means to deport people. So long story short, this is something that we should be aware of, and it's called the shadow docket for good reason. There's some controversy within the court about that term. It's interesting that in 2021, a writer from the Atlantic magazine called out Samuel Alito about this process, and Samuel Alito, who's the most thin-skinned of all the justices, far more than Clarence Thomas. And he actually threw a hissy fit at a speech that he gave at Notre Dame University about this writer, Adam Server's article, in which he tried to call attention to the court's use of the shadow docket. And the particular case that Server was writing about involved the Texas abortion law, where, if you remember, that was one where they were allowing private plaintiffs to enforce the law, and they still do. And that was one where the plaintiffs wanted to get an injunction against the implementation of that statute. And this occurred before Dobbs, and the Supreme Court turned them down. So the court's aware of it. I think they're a little embarrassed about the way things are going. They've created a monster in the president. I think they would rather that Donald Trump behave better, but they're stuck with the monster that they created, and so are we. I am a little encouraged, even though Abrego Garcia was brought back to face criminal charges, that he was brought back.
Yeah.
And they're complying with an order to facilitate his return. Whereas a couple of days ago, it looked like they were never going to comply. The Trump administration would not comply. Now they did in their own way.
So it seemed that they were making a distinction between facilitating his return and effectuating his return. And so are you suggesting that they're now not making that distinction anymore? And they're
No, it's hard to say. I'm heartened by the fact that he's returned. There's no way that El Salvador would have released him if the Trump administration had not demanded that he be brought back. So the fact that they're doing it, that they're bringing him back after the Supreme Court issues this decision, is a sign, which may of course be temporary, that the Trump administration is not yet ready to openly defy the Supreme Court. That's a good thing. I'm also encouraged by this feud between Musk and Trump because it shows just how crazy at the highest level the MAGA coalition is. And you have the battle between these two gigantic egos that place their own feelings above the well-being of the rest of us. So there are these cracks in the wall. And I'm not totally pessimistic about the direction of the country, but I do want to be clear that this is a very, very conservative Supreme Court and have no illusions about it. And John Roberts is, he's not Clarence Thomas, he's not Samuel Alito, he's not Neil Gorsuch, but he's very, very conservative. After all, he's the author of Shelby County versus Holder, the decision that gutted the Voting Rights Act, one of the worst decisions, in my view, in the history of the court. So he's the Chief Justice. All this talk about him being an institutionalist, I think, is highly overblown. He's first and foremost a conservative and an activist. He's also an institutionalist, but he's all of those things. So for progressives, not a hero, not a savior.
So I want to make some clear distinctions between this merit docket and the shadow docket. I mean, you've made it clear that the shadow docket takes on these emergency cases. I don't know what criteria they use to determine whether or they, being the Supreme Court justices, I don't know what criteria they use to determine whether something is an emergency. You said something about having high profile cases, but a couple of other things come to mind, and that is from the research that I was doing, a shadow docket versus a merit docket receives less public scrutiny and often escapes public attention, possibly because it doesn't last as long. The trial, there's no oral argument, and
Right.
and the decision is made within hours or days. What
Well,
I
not necessarily within hours, but go ahead.
One thing I was wondering about is the impact in terms of setting precedent. So the research I did, clearly precedent is set on a merit document, but from my research, it says that the shadow docket doesn't necessarily establish precedent.
You know,
Now,
that's an open question. It's really interesting. There are law review articles on that. But if you look up some of the longer shadow docket decisions, they're included in the U.S. reports and the official reports of the Supreme Court. So does it establish precedent? It's a good question. You'd be hard pressed if you were a lower court judge to rule contrary to a shadow docket ruling. So you're not going to see another lower court judge saying, Doge, you have no access to Social Security records. It's not going to happen. So is it precedent? That's why I wrote they have the same, in many cases, the same practical effect as a final decision. And what makes the shadow docket, what are the criteria? I don't think it's all that much of a mystery. The Supreme Court is confronted with a lower court order in the Doge case, for example, saying, Doge, you can't look through the Social Security records. That's the law of the case until the Supreme Court comes along and says it's not the law of the case. So that's why they take it.
yeah. Well, I'm glad that you are remaining hopeful, Bill.
I don't
Well,
think he said
yeah.
that he was hopeful. I think he said he wasn't totally depressed about it. But, to me, it seems as a layperson who doesn't understand all the intricacies, just seems like another way that our institutions, our traditional, our media, our court system, up and down the line is standing aside for Trump. And we can sit here and hope that Trump and Musk have a big enough argument and the wheels fall off. But it's not in their interest not to keep moving forward. So, and if the court won't get in the way, I don't know what will stop Trump's people from their worst impulses.
So
Well,
let me just ask one quick question about the shadow document, because Bill, you said that the term was coined by a professor, and I don't know, but like in 2015. But
correct.
Does that mean that, he created the term, so he gave it a name,
Gave
but
it a
the
name.
actual Supreme Court taking on emergency cases, that was something that was going on.
Well, it's always taken on some cases on an emergency basis, and that's not a bad thing. Let's say you're facing the death penalty and you have
Yes.
a midnight
Right.
request for a stay. That's a good thing. So what's proliferated is the number of important decisions that the Supreme Court hands down on this expedited basis with summary decisions. And that's what's called the shadow docket. If you look at the merits docket, and the merits docket is a legal term. Every year, the Supreme Court will have a list of its merits docket, which it fills throughout each term. You can see that the number of merits docket cases has declined over the past decade. Used to be over 80 cases. Then a couple of years ago, went down to 53. I think to this term, they're going to be 61. So I don't know what these guys are doing with their time, because lower court judges are really, really busy. And one way that they're filling their time is handling another bunch of cases on an expedited basis, which we call the shadow docket. And yes, it is a pejorative term, but I think it's a good term because it's a bunch of cases that are handled with minimal transparency, and we shouldn't have that in our system of justice. And I think this is a little different from what Dick said. I think the lower courts are doing a really good job standing up to Trump. It's the Supreme.
But Trump's people never give up. They don't accept the lower court rulings. I mean, if they can get away with it, they move it up to the Supreme Court, and the Supreme Court does this magic and reverses it.
That's right. Not in every case, but the overwhelming majority, it seems, because the Supreme Court, to me, agrees with Trump's agenda, agrees with the MAGA agenda. It's a reactionary court from the legal philosophy of originalism to this history and tradition test that it uses for the Second Amendment and anything else it wants to apply it to. It's a very, very backwards looking court, which tries to return the United States to, say, where it was in the 1920s legally. This is all part of the dismantling of the administrative state. And the case I led with in that column, Trump v. Wilcox, dealt with the firing of two commissioners, one from the National Labor Relations Board and the other from the Merits Board that reviews federal employee civil service actions, both quasi-legal, quasi-judicial organization entities that are supposed to be independent. So the Supreme Court lifts an injunction saying you got to rehire these two commissioners. And now with that injunction lifted, those individuals are fired. And the court is saying that the government's likely to prevail, that the president does have the power under the unitary theory of the executive to fire everyone in the executive branch that he doesn't like, reversing decades of precedent. However, it's interesting, they carved out an exception for the Federal Reserve. They went out of their way. And it's interesting why they did. You know, you really don't know. They say, oh, the Federal Reserve has this history of independence. Well, so do the others. But I think it's because they don't want to cause economic chaos. Unlike some of the MAGA people, Supreme Court wants the capitalist system to function smoothly, but not on behalf of working people or minorities. And so they went out of their way to say this ruling doesn't apply to the Federal Reserve. They were sort of telling Trump, you can't file Fed chair.
Yeah, hands off.
We've been hearing that you want to do that, but you're not going to be able to do it. Otherwise it's what we call dicta. It's just an aside in a decision that's about two other commissioners who work for different agencies. The Federal Reserve isn't a party to this case. So they went out of their way to comment on the Federal Reserve, to send a message to Donald Trump. And as I said earlier, it's not 100% bad, because in the case where they said you can't use the Alien Enemies Act, remember, they said everybody's entitled to due process, even though they didn't really spell out what that was. Some kind of notice and the right to file a habeas petition. Not adequate, but it's better than nothing. And the Trump administration apparently complied with the decision. Now they brought him back. They're going to try him criminally, and then they're going to deport him again.
Right.
But they did bring him back. So I think that's significant. The time may come when Trump openly defies the court, but I think his popularity is so declining. And I think that in terms of his personal abilities, he's greatly diminished from the person he used to be. And that's showing. So, I don't think there's anyone to take his place. There are certainly smarter people in his administration, but there's nobody as charismatic and nobody who's as popular who can carry who can shoulder the burden of the MAGA movement. It isn't going to be Stephen Miller. He's horrifically unpopular. Although I think Stephen Miller's pretty smart. Some people think he isn't. I do. I disagree. It's not going to be this guy who runs the Office of Management and Budget, Russell Vought. It's not even going to be J.D. Vance, who's got no charisma. So I think Donald Trump's diminishing. It's not over. And as he goes down the drain, if he is going to go down the drain, he'll stay nasty, maybe get a little nastier. And I do think he's looking for his little Reichstag fire moment so he can be even more authoritarian. And who knows, maybe it'll come on the 14th, 8 days from now. Some people will do something to give him a pretext for calling out the military on demonstrators. I mean, he's already having his parade.
Yeah.
We have an article in the queue from France at the Military Religious Freedom Foundation. It's an organization of former military officers mostly. And they say in this article that the word inside the Pentagon is that Hegseth is going to make all officers, major and above, sign a personal loyalty oath to Donald Trump.
Interesting. I do think that'll certainly be ruled unconstitutional by the lower courts, and I would think that even the Supreme Court would find that unconstitutional.
Yeah. Well, you just heard this third party. We don't know that is actually happening, right?
Right.
Okay.
Yeah.
Well,
Pete Hegseth, just so we can end on this note. I talk about Russell Vought, Stephen Miller, J.D. Vance. These are smart people lacking charisma. Pete Hegseth doesn't have charisma, and he's not very smart, so he doesn't fit either of those categories.
Yeah, well, Trump knew what he was doing when he was appointing various people to fill positions in his administration. He really does not want anyone who is charismatic, because he doesn't want any true competition.
No, he doesn't at all.
Okay, Bill. Well, it's a pleasure again learning so much from you, Bill Blum. Thank you so much. If you want to read the article, it's How the Supreme Court Shadow Docket Facilitates Trump's Power Grab. It's at the laprogressive.com. Please subscribe. Please share. And we'll see you guys soon.
See you, Bill.
Thank you.
Thank you.
Thank you for sticking around. If you like the LA Progressive content and the discussions we have here, please consider clicking the subscribe button below, and also give us a thumbs up. That helps to grow our audience by feeding the algorithm, which helps to get this content in front of more eyes. Thanks for stopping by. We really appreciate your support.